Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Aisyah Kisina binti Muhammad Hilmi with metric number of 2415770 and my partner Amna binti Amma 2410956. We are going to present on constitutional law. So we're going to start with the facts of the case. So in the state general election held on 13 December 2022, the National Alliance, comprising the Religious Party, the Unity Party, won 14 of the 15 state seats, with RP securing 9 seats and UP 5 seats. The Reform Coalition, through the Honest Party, won 1 seat. Following the election, Haji Rafa of RP was appointed as Menteri Besar on 15 December 2022 and the State Legislative Assembly was summoned and convened on 19 December 2022. On 23rd December of 2025, the Sultan received a statutory declarations filed by 8 assemblymen from the National Alliance, 3 from RP, 5 from UP, withdrawing their support for Haji Rafa as the Menteri Besar. On the 24th December, the President of RP announced that the party membership of the 3 assemblymen of RP who withdrew their support for Haji Rafa had ceased with immediate effect. On December 2025, Haji Rafa attempted to request the Sultan to dissolve the assembly but was unable to do so as it was a public holiday. On the morning of 26 December, the palace announced the appointment of Mr. Elvis as the new Menteri Besar. He was sworn in early that day in the presence of 5 UP assemblymen, 1 HP assemblyman and the 3 RP assemblymen who had withdrawn the support from Haji Rafa. Later on, 26 December, the Speaker notified the Election Commission of 3 casual vacancies of the 3 RP arising from the cessation of the party membership of the TRP assemblymen. Haji Rafa claims that he remains the rightful Menteri Besar as he neither resigned nor was dismissed by the Sultan and argues that Mr. Elvis lacked the majority support. Mr. Elvis disputes this, asserting that he commands the majority support and the Sultan's appointment of Menteri Besar is a discretionary and non-justifiable act. Next, we're going to start with the first issue, whether Haji Rafa has lost the confidence of majority of the State Legislative Assembly and the subsequent effect on his position. So we refer to Section 2, Subsection 6 of the 8th Schedule of the Federal Constitutions. Once the Menteri Besar ceases to command the confidence of the majority of members of Legislative Assembly, then unless at his request, the ruler dissolve the Legislative Assembly, he shall tender the resignation of the Executive Council. So we refer to the case of Datuk Amir Kahar, Tun Datuk Haji Mustafa and Datuk Muhammad Said Kerwa, 1995. And in this case, the issue is whether the Chief Minister had lost the confidence of majority of the Legislative Assembly. So the court held that the loss of confidence does not require a formal vote in the Assembly and may be proven through properly established extraneous evidence such as petition or admission by the Chief Minister. So in this case, 30 assemblymen had petitioned on the removal of Chief Minister, and also the Chief Minister admits of him not commanding the majority support. We also took the case of Datuk Sri IR Haji Muhammad Nizar Jamaluddin and Datuk Sri Dr. Zamri Abdul Kadir 2010. In this case, after the 2008 Perak state election, Pakatan Rakyat won a majority and the appellant was appointed by Chief Minister. In February 2009, 3 assemblymen withdrew their support, causing the Sultan to conclude that the appellant had lost majority confidence. So the Sultan refused dissolution and directed the appellant to resign, subsequently appointed the respondent as the new Chief Minister. So the appellant challenged the appointment, arguing that there was no vote of no confidence and that he had not resigned. So the issue is that whether motion of no confidence is required to dismiss the Chief Minister. So the court held that the loss of confidence in a Menteri Besar did not be shown by a formal vote, but it may be proven through properly established extraneous evidence. So to apply in this case, the statutory declarations made by 8 assemblymen were received by the Sultan on 23rd December 2025 especially withdrawing their support for Haji Rafah. So the statutory declarations are properly established extraneous evidence as referred to the case that I mentioned before. And moreover, the total number of the assemblymen in the Legislative Assembly is 15. So the required majority confidence would be 8 members. The support by 8 members. So in this case, the majority confidence by the assembly members no longer present. So to conclude, based on Section 2, subsection 6 of the 8th Schedule, and the principle established in Datuk Amir Kahar and Datuk Sri IR Haji Muhammad Nizar Jamaluddin, Haji Rafah had lost the confidence of majority of the State Legislative Assembly through properly established extraneous evidence in the form of statutory declarations submitted by the 8 assemblymen. So Haji Rafah cannot lawfully continue to hold the position of the Menteri Besar. We are going to go with sub-issue, whether the Sultan was constitutionally entitled to refuse Haji Rafah request for dissolution of the State Legislative Assembly and instead appoint a new Menteri Besar named Mr. Elvis. So under Section 2, subsection 6 of the 8th Schedule of the Federal Constitution, once the Menteri Besar ceases to command the confidence of majority of the members of Legislative Assembly, he shall tender resignation of the Executive Council, or he have to request the ruler to dissolve the Legislative Assembly. However, the dissolution of Legislative Assembly is not binding upon the Sultan. It is up to the Sultan's discretionary power. In the case of Datuk Sri IR Haji Muhammad Nizar Jamaluddin, the court held that the word shall imposes mandatory effect, whereby the appellant in this case was obligated to tender resignation of the Executive Council once he has been directed to do so by the Sultan. So it is not up to him to whether he wants to stay or he wants to resign from being a Menteri Besar, as it will lead to political uncertainty. And we also took the Section 1, subsection 2b of the 8th Schedule, where the ruler may act in his discretion in the performance of the withholding of consent to request for the dissolution of the Legislative Assembly. So to apply in our case, although the Section 2, subsection 6 of the 8th Schedule allow the Menteri Besar to request for dissolution, the request is not binding on the Sultan and remains subject to his discretion. So Haji Rafah's attempt to request for dissolution when he went to the palace was not granted, and the Sultan instead appointed new Menteri Besar, Mr. Elvis, the next day after concluding that he had the majority support. So, consistent with Datuk Sri IR Haji Muhammad Nizar Jamaluddin against Datuk Sri Dr. Zamri Abdul Kadir, once a Menteri Besar loses confidence, the resignation is mandatory if the dissolution is not granted by the Sultan. So to conclude, the Sultan was constitutionally entitled to refuse Haji Rafah's request for dissolution of the State Legislative Assembly, as Haji Rafah had lost the confidence of majority and the dissolution was not granted. His resignation became mandatory under Section 2, subsection 6 of the 8th Schedule, and accordingly, the Sultan acted within his constitutional discretion in appointing Mr. Elvis as the new Menteri Besar.
Assalamualaikum warahmatullahi wabarakatuh. So my name is Amna binti Ammar, matrix number 2410956, and today I will be continuing the discussion on to the second legal issue, in which whether Mr. Elvis' appointment as a chief minister is considered valid. And to constitute to this decision, we have divided it into 3 sub-issues, in which the first one is that whether Mr. Elvis' appointment as a chief minister follows a valid procedure. So for this, we have taken the authority of Article 71 of the Federal Constitution, in which a constitutional guarantee for the states, as this article stipulates that the Federation shall ensure the provision of a state constitution for every state, and crucially mandates that each state constitution must contain a set of essential provisions. So among these mandatory provision is the entire process to the formation of the state executive branch, which includes the appointment of the Menteri Besar. And in effect, the Federal Constitution provides a master template compelling all states to adopt a democratic system model on the federal process to appointing the Prime Minister, in which is thereby ensuring for uniformity on the part of the parliamentary democracy across the nation. And next, we will look into the procedure to appoint the Chief Minister itself, in which by way of election. So for the first one is that the procedure itself is following a state general election, in which the population themselves elects their representative to the state legislative assembly, which it is an immediate task to determine which elected assemblyman commands the majority's confidence, and hence in a straightforward election there is a single political party or a pre-election coalition wins more than half of the total seats, and the process itself is simple, and that the leader of the winning party will be presumed to have the majority of the confidence and is typically invited by the ruler to be appointed as a Menteri Besar, which reflects a clear mandate from the electorate. However, the situation becomes more complicated in the event of a hung assembly, where there is no single party or coalition that secures a simple majority. And in such cases, the ruler is required to exercise their constitutional discretion, in which this discretion is not absolute or based on personal preference, as it is the duty of the impartial arbiter to safeguard the democratic stability, and the ruler must consult with the leaders of all major political parties. Thereby, it may require them to submit evidence, such as the statutory declaration of support from the assemblyman, to prove their clear majority, and that this objective is to identify the individual who is the most capable of forming a stable government that can survive a vote of confidence on the floor of the assembly. And once the ruler is satisfied that a particular candidate had contested and demonstrably commands the confidence of the majority, the appointment is thereby formalized, in which the ruler will issue an official instrument of appointment, naming the chosen individual as the Menteri Besar, and this is followed by a swearing-in ceremony, such as in our scenario here, where the appointee takes the oath of office and oath of secrecy before the ruler. It is only after this solemn ceremony that the Menteri Besar is constitutionally empowered to assume their duties, in which they will select and appoint the members of the State Executive Council. Also look into the anti-hopping law, in which it prevents elected politicians such as the MPs and assemblymen from switching parties after being elected, with the aim to stop the political instability, where the MPs and the assemblymen can just jump from one party to another, where a representative defect may potentially overturn the election results and undermine the voter mandates. And we will also look into the casual vacancy, in which, in accordance with Article 54 of the Federal Constitution, it was stated that such casual vacancy shall be filled within 60 days from the date established by the Election Commission. So to apply in this scenario, it is clear that Haji Rafah has lost the constitutional authority to govern, as his coalition's majority of 14 seats was shattered when 8 of the assemblymen formally withdrew their support, thereby reducing his backing to a mere 6 members in the 15-seat assembly. And this loss of confidence triggered his duty to resign or seek dissolution, in which his request for dissolution was lawfully rejected by the Sultan, who then correctly moved to identify an alternative leader with majority support, which in this case is Mr. Alvis, and the Sultan based his decision on the statutory declarations and a public swearing ceremony attended by 9 assemblymen, provided the procedural appointment of Mr. Alvis as a Menteri Besar was constitutionally valid, as the Sultan had acted correctly within his discretionary power after it was demonstrated proven that Haji Rafah was no longer commanding the confidence of the majority. So now we will move on into the second sub-issues, in which whether Mr. Alvis' appointment can be challenged by Haji Rafah on the ground of lack of support. And to reiterate these sub-issues better is that whether the status of the 3 assemblymen that ceases to be the members of the House of Representatives renders them to be invalid of their support. And to look into this, we have taken the Constitutional Amendment Act 2022, where the moment these individuals were expelled or ceased to be members of the party for which they were elected, they forfeited their status of as members of the SLA because their vacancy occurs by operation of law rather than the speaker's discretion himself. Hence, the 3 seats were already legally casual vacancies well before the 6 a.m. swearing in on December 26. So, according to Article 49A, Clause A1(2), a member of the House of Representatives shall cease to be a member of the House, and his seat shall be vacant immediately by way of casual vacancies if he ceases to be a member of the political party. Additionally, a lack of majority of support does not contribute to the governing party to lose power, as the Sultan may install what is called as a minority government to take place by relying on the ad hoc support of the willing MPs to survive the no confidence motion to pass the budgets and secure essential legislations, in which this minority government is considered as a weak government, but it is also generally led to early dismissal. However, according to Faruqi 2019, constitutionalism is that of a government that is elected, represented, and of a responsible one, so it does not matter whether the government is considered as weak or as a strong one. So thereby consequently, to apply in this scenario, the validity of the assemblyman from which a majority could be drawn had shrank from 15 to only 12. Therefore, in this reduced assembly, the threshold for a simple majority is shrink as half have been shifted to at least 7 members, and since the 3 expelled RP members had legally lost their seats, they could no longer be counted as a valid supporters of Mr. Elvis. Thereby, this leaves Mr. Elvis with only 6 supporters, with that being 5 from the UP and 1 from HP. Thereby, it constitutes exactly 50% and it is not a majority. And this showcases that Mr. Elvis failed to meet the constitutional requirement of commanding the confidence of the majority of the assembly at the time of his appointment. Thus, Mr. Elvis' remaining support would be only that of the 6 members, and the validity of Mr. Elvis' appointment is directly dependent on the impact of the anti-hopping provision. Next, we will move on to the last sub-issues, in which is the third one on whether the Sultan's discretion in appointing a Menteri Besar is entirely non-justiciable and therefore absolutely immune from judicial review as broadly asserted by Mr. Elvis. So for this, we have taken the section 2, clause 2A, where the ruler shall first appoint as Menteri Besar to preside over the Executive Council a member of the Legislative Assembly who in his judgment is likely to command the confidence of the majority of the members of the Assembly. And to apply to this legal framework to Mr. Elvis' assertion that it is non-justiciable, it becomes clear that his claim of absolute non-justiciability is overly simplistic and legally flawed, as Mr. Elvis had correctly identifies the Sultan's discretion. However, he erroneously extends his protection to the entire appointment, thereby ignoring the crucial condition precedent in which the requirement of the majority confidence. And the courts would not intervene to question why the Sultan preferred one candidate over another or to substitute the Sultan's judgment with its own. Such an inquiry into the subjective mind of the Sultan would be non-justiciable. And specifically, this question is whether the courts have any jurisdiction on to examine the circumstances surrounding an appointment, or if the matters is confined solely to the royal prerogative, therefore making any court intervention unconstitutional. So the governing legal principle is a nuanced doctrine that balances the sanctity of the royal prerogative and also the supremacy of the constitution itself. And therefore, its fundamental role is that while a Sultan's personal judgment or discretion, satisfaction and discretion in the act of choosing a Menteri Besar are generally non-justiciable, the legal foundation is that the discretion is exercised as being fully justiciable, and the Constitution does not grant the Sultan absolute or unfettered power to mandate the appointment he made of an individual who is likely to command the confidence of the majority of the members of the Legislative Assembly. Hence, his constitutional prerequisite is not a matter of mere formality, but a substantive requirement that form the bedrock of the Sultan's discretion, and it is these very foundations that the court are empowered to scrutinize. And this was firmly established in the landmark case of Perak, in which in the case of Nizar against Zamri, where the federal court was asked to determine the legitimate Menteri Besar, after a series of defections caused a shift in the majority, where the court held that the Sultan was correct to determine who commanded the majority based on convincing evidence, such as the statutory declaration, as in our scenario just now, and that the waiting period for a formal vote of no confidence in the assembly. So crucially, the court have affirmed that the role of the arbiter to verify the facts upon the Sultan's discretion was based, and similarly this can be seen in the Terengganu crisis of 2008, where the Sultan himself refused to appoint the candidate from the winning coalition who had the undisputed majority, as he is initially opting for another. And then, while resolved politically, the crisis highlighted the principle that the Sultan's discretion is not absolute and is exercised based on the factual reality of majority support within the Legislative Assembly. These cases collectively confirm that the court have a constitutional duty to ensure that the appointment process adheres to the explicit requirement of commanding a majority. So to apply this legal framework to Mr. Alvis' assertion that it becomes clear that his claim of absolute non-justiciability is overly simplistic and legally flawed. So this claim of Mr. Alvis that the Sultan appointment of the Menteri Besar is entirely non-justiciable is incorrect, as the inner workings of the Sultan's judgment are shielded from review. However, the appointment itself is not beyond the court's constitutional reach, as the court possesses the clear jurisdiction and duty to intervene and determine whether the fundamental prerequisite that the appointed person commands, the confidence of the majority of the State Legislative Assembly, has been satisfied. And with that, we end our presentation, and thank you, Doctor, for your time.